Hello viewers, welcome to my channel. I'm Hasham Ali Khan. So in this video I'm going to explain you about the company liquidator, appointment of company liquidator, and what are the reports to be submitted by liquidator. These are the things I'm going to explain in this video. Last video I have explained you the meaning of winding up. What are the different methods of winding up, that is compulsory winding up and voluntary winding up. What are the grounds on which the tribunal will pass the order for compulsory winding up? And what is the procedure, steps involved in voluntary winding up? All these things I have explained in the last video. If you have not watched that video, I suggest you to go to the playlist of my channel. Select the subject business law. Select the topic winding up of companies. Definitely you will get good command on the provisions of the Companies Act regarding winding up. So now I'm going to explain you about the liquidator. So in ordinary language we can say liquidator is the person who is appointed at the time of winding up. He will take charge of the company in the liquidation process. He will settle all the accounts and wind up the company. In simple words we can say liquidator is that person who is appointed to take charge of the company. Now a liquidator or an official receiver, he is also called an official receiver, manages the entire liquidation process. The complete winding up process, liquidation process is in the hands of the official receiver or liquidator. He or she is appointed when a company goes into liquidation. So during the lifetime, liquidator will not be appointed. Only at the time of winding up, liquidator will be appointed by the court in the case of compulsory winding up process. So court will appoint a person to take charge of the company for liquidation process. A company liquidator is an official appointed for the purpose of winding up of company. Simple words we can say. Company liquidator is the official person who is appointed in order to bring the company to an end, to make all the liquidation process. So section 2 subsection 23 of the Companies Act 2013 defines the company liquidator as under. One definition is given under section 2 subsection 23 by the Companies Act. It says liquidator means company liquidator insofar as it relates to winding up of company means a person appointed as company liquidator by. The definition means he has not given the meaning of the term liquidator. The law says liquidator from the sense insofar as relates to liquidator of company means a person who is appointed by the tribunal in case of compulsory winding up. The liquidator is the person who is appointed by tribunal in the case of compulsory winding up, and the company or creditors in case of voluntary winding up. That means we have two types of winding up, compulsory winding up and voluntary. If it is a compulsory winding up by the tribunal will appoint a person as company liquidator. Similarly, if the winding up is the voluntary winding up, the liquidator will be appointed by the company or the creditors. He is appointed to take control over the control of the company. When the liquidator is appointed, he will take charge, he will take the control of the company. What he will do? He will realize all the assets, payment of debts, and distribution of surplus among the members of the company. So the main job of the liquidator is realize all the assets, collect the amount from sale of all assets, settle all the outside liabilities, debts, and the remaining surplus will be distributed among the members in proportion to their rights. This is the explanation of the term liquidator. Now, appointment of liquidator. First, appointment of official liquidator as company liquidator. So in case of compulsory winding up, the liquidator will be appointed by the tribunal. At the time of passing an order of winding up, tribunal must appoint an official liquidator as company liquidator. Even a provisional liquidator is appointed to carry out the proceedings of winding up of the company. So at the time of winding up, the tribunal will appoint a liquidator, official liquidator or provisional liquidator. Terms and conditions of appointment. The terms and conditions relating to appointment of provisional liquidator or company liquidator remuneration payable is decided by the tribunal. So ultimately all the terms, conditions, remuneration of official liquidator or provisional liquidator will be decided by the tribunal, and it should be on the basis of performance task. It should be on the basis of quantum of work, experience, qualification and size of the company. Remuneration depends on the performance task, the experience of the liquidator, qualification of liquidator and the size of the company. Next, declaration by the company liquidator. If the liquidator has accepted the job of liquidation, then he has to intimate. The liquidator must file a declaration within 7 days of his being appointed as provisional liquidator or company liquidator in the prescribed form. The prescribed format is there. Within 7 days of his appointment as a liquidator, he should submit, he should file a return that he is appointed as liquidator in the prescribed format. So these are the steps on appointment of liquidator. So after completing the job of liquidation, what are the reports to be made by liquidator and submitted to the tribunal that we are discussing now? What are the reports of the company liquidator? Following are the provisions relating to report of company liquidator. Some points are given, some provisions are given that are how the liquidator has to make a report, and this report will be submitted to the tribunal. Within 60 days of winding up order, the company liquidator must submit its report to the tribunal. The time period is given. Within 60 days of winding up order, he has to submit a report to the tribunal. The contents of the report are as follows. In this report, what are the contents the liquidator has to include? First one, complete details regarding assets of the company along with capital amount issued, subscribed, paid up. In the report, the liquidator has to specify how much are the assets, realizable value of assets, and then capital of the company, showing the details regarding subscribed capital and paid up capital, etc. Details of existing and contingent liability of the company and any debts due to the company. So in the report, the liquidator has to specify how much are the liabilities, actual liabilities and contingent liabilities, and how much are the amount due from others to the company. Then third one, guarantee extended by a company and list of contributories and call due by them. Guarantees given by the company and also the contributories and how much is the call due from contributory. Actually, contributory means the shareholders at the time of winding up. When the company is being in the process of winding up, the shareholders are called contributories. And how much is the amount due on calls from contributory. Then details regarding holding and subsidiary companies. If this company which is being wound up have any holding company or subsidiary company, that we have to show it. Information relating to subsisting contracts and legal cases filed by or against the company. Any legal cases are filed by the company or against the company. All the legal cases must be specified in the report. Any other information which tribunal find it as essential must be included. So if the tribunal has given wide powers, they can give instruction on anything to be extracted from the company, and report should be given by the liquidator. Then the company liquidator must prepare a report in the way in which the company was formed. A report must also give the opinion of the liquidator relating to any fraud committed since formation and even matters which he like to bring it to the notice of tribunal. The tribunal has given the responsibility. He has to give the report regarding any fraud were conducted since the formation of the company and any other thing which he has noticed while doing the liquidation. That point he has to bring it to the notice of tribunal. He has to write it in the report of the tribunal. A report on viability of the business must be prepared. Viability of the business. Is the business solvent or insolvent? What is the financial position of the business? Viability report has to give. Company liquidator is eligible to make any further report or reports. There is no limit what information he has to give. If any other report, any other information the liquidator wants to give to the tribunal, the liquidator has to give the report. The report made by the company liquidator can be inspected at any time by any creditor. Whatever report the liquidator has made and that is submitted to the tribunal, that report is available for inspection to the creditor, by any creditor or contributory shareholders of the company, and are also eligible to take copies and extract information by paying prescribed fees. The law has given the provision that the liquidator or the contributory can inspect the report of the liquidator. Inspect the report. Not only they can inspect, they can extract the copies of the report by paying the prescribed fee. So these are the provisions regarding the reports prepared by the liquidator and submitted to the tribunal. So I have explained you about the meaning of the term company liquidator and appointment, provisions regarding appointment of liquidator and reports submitted by liquidator to the tribunal. Come on, now we'll discuss the powers and duties of liquidator, company liquidator. So first of all, I'm going to explain you about the powers. In order to function, in order to proper discharge his duties, some powers are given by the Companies Act 2013 to the liquidator. So what are the powers in the hands of liquidator to perform his duties? First power, to bring or defend any legal action, either civil legal action or criminal, in the name of the company and on behalf of the company. The first power in the hands of the liquidator is they can bring or defend any legal actions, whether civil or criminal, in the name of the company or on behalf of the company. That is the first power. Second, to appoint an advocate, attorney or pleader to assist him in the performance of his functions. So when the liquidator feels that he needs the assistance of an advocate or attorney or pleader, he can appoint. That is his power. Then next one, to carry on the business of the company so far as is necessary for the beneficial winding up of the company. Actually, when the company is wound up, the business will be stopped. But in certain circumstances, the liquidator will have the power to continue the business because it will be beneficial for the proper winding up of the business. So if the liquidator feels that it is required to continue the business for the beneficial winding up of the business, he can carry on the business. That is also his power. Then to sell movable or immobile property of the company either by private contracts or by public option. Because one of the function of the liquidator is to sell away all assets, realize the cash, make the payment for liabilities and settle the account of the contributories or members. So in order to function that, the movable or immobile property can be sold by the liquidator either by private contracts or by making public auctions. The next one is to raise loans on the security of the assets if necessary. Sometimes the liquidator will be short of cash. He needs some cash, so he can raise a loan on the security of the assets if it is required. If it is required for the proper conduct of winding up, he is in need of money, so he can raise a loan on the security of the assets. Next one, to do all other things necessary for the winding up of the affairs of the company and distributing his assets. That means whatever duty he is required, whatever functions he required to properly wound up the company, he can do all the functions in order to realize the assets, in order to make the payment for liabilities. So all the activities which are required for properly winding up of the company, he can perform. That is the one of the power. Next one is to pay any class of creditors in full or make a compromise or arrangement with the creditors. It is the responsibility of the liquidator to make the payment to creditors. Creditors are the liabilities, the amount owed by the company to outsiders. The amount owed by the company to outsider, that is the creditor. So it is the responsibility, it is the power of the liquidator to make the payment in full or make a compromise or arrangement with the creditor in order to make the payments. Next one is to compromise calls, debts and other pecuniary liabilities with contributories and debtors, and to accept any security in discharge of such a claim or give a complete discharge in respect thereof. That means the liquidator has the power to make a compromise with the amount receivable from contributories, from debtors and other pecuniary liability with contributory debtor, and accept any security, either getting the full amount or getting a partial amount. He has the power. Next one is to disclaim any onerous property or unprofitable contracts. Unprofitable contracts. So he can disclaim any onerous property or disclaim any unprofitable contracts. So these are few powers in the hands of liquidator. Now, what are the duties of liquidator? What are the functions? What are the duties, responsibilities to conduct proceedings in winding up? That means winding up is a process. It requires a number of activities. The liquidator has to perform all the proceedings which are required for smooth winding up of the company. Second, to submit preliminary report time to time. The liquidator has to submit a report to the tribunal and reports to company. So a number of reports he has to make, that is his duty. So immediately on the receipt of statement of affairs from the directors, whenever a company is wound up, within a specified period, the company has to make a statement. That statement is called statement of affairs. And this statement must list down what are the assets available, what are the liabilities payable, and what is the capital of the company. So in this statement of affairs, all these information will be written. This is prepared by the board of directors and it will be given to the liquidator. The liquidator can start his job, can start his work only after getting the statement of affairs. So immediately on the receipt of statement of affairs from the director and within 6 months from the date of winding up order, the liquidator shall submit to the tribunal a preliminary report with regard to capital issued, subscribed and paid up capital, estimated amount of assets and liabilities, causes of failure of the company. So within 6 months from the date of getting statement of affairs, within 6 months, it is the duty of the liquidator to make a report. And submit it to the tribunal. In this report, he has to specify how much is the capital, how much is the issued capital, subscribed capital, paid up capital, what is the realizable value of assets, and what are the amount of liabilities payable. All these things he has to make a preliminary report, and it should be submitted within 6 months from the date of receiving the statement of affairs. Next one is collection and distributing of company's property. Collection and distributing of company's property. Immediately after the petition of liquidation of the company is accepted and the winding up order is made by the court, all the property and assets of the company shall vest in the liquidator. That means it is the duty of the liquidator to take charge of all the assets and properties of the company, because it is his responsibility, his duty to dispose of all the assets, realize the cash. So one of the duty is he has to take a charge of all the assets and properties, to obey the orders of tribunal. Earlier it was court, but according to New Companies Act 2013, the powers has been given to the tribunal, that is called Company Law Board Tribunal. So official liquidator shall not obey the orders and carry out advice and direction of the court, but shall also care to see that his action do not come to be ultra vires the provisions of company law. See here, actually the liquidator has to get the orders, has to obey the orders given by the tribunal, but at the same time he has to see that his action, that his activities should not be ultra vires the provision of company law. Here we have company law. The orders of tribunal should not override the provisions of company law. That means whatever orders he is getting from tribunal, That means that should be within the ambit of company law provisions. It should not be ultra vires. Ultra vires means beyond the powers of company law. Next, meeting of creditors and contributories. It is the duty of the liquidator to convene the meeting of creditors and contributories. Contributories are the members, shareholders. When the company winding up proceedings started, we will not call them as shareholders. We call them as contributories. So in reality, shareholders and contributories means one and the same. So before winding up, they are the shareholders. At the time of winding up and after that, they will become contributories. So here, meeting, the liquidator shall call the meeting of creditors and contributories whenever he may deem fit. Whenever it is required, he can call the meeting. Next one, to maintain proper books. It is the duty of the liquidator to maintain proper books. Proper minutes he has to make. So the liquidator shall keep in the manner prescribed proper books, in which shall cause the entries or minutes to be made in the proceedings at the meeting, and such other matters as may be prescribed. The tribunal has prescribed that what are the books he has to maintain, what are the records he has to keep for all the meetings, for all the proceedings and the minutes made. So all these things should be systematically recorded in proper books of accounts, which are prescribed by the tribunal. That is also one of the duty. Next one is to account for money received by him. Whatever money he has received, he has to account it. That means the liquidator has to make a liquidator's final statement of account. In that account, he has to write down each and every amount he has received on account of winding up. The liquidator shall pay all cash collection made by him. Appointment of committee of inspection. So the liquidator will have to appoint a committee of inspection to assist him if the tribunal so directs. If the tribunal feels that a committee is required to assist the liquidator, then the liquidator shall appoint a committee which will assist him, which will assist the liquidator in smoothly performing his functions of winding up. So he should convene a meeting of the creditors within 2 months from the date of court's direction for purpose of determining who are the members of committee. So who are the members of the committee? He has to decide by convening a meeting of the creditors. Next function, next duty is the periodical report shall be submitted by the company liquidator at the end of each quarter. At the end of each quarter, at the end of every 3 months, the company has to send a report to the tribunal regarding what are the activities that have been done during the quarter regarding the winding up of the company. And this show the progress of the winding up of the company in specified form. Because this winding up cannot take place instantaneously, immediately, it cannot be done in one shot, so it will take a lot of time. So during this 1 quarter period, what are the things that have been done by the liquidator? A report has to be submitted to the tribunal every quarter. Then the company's liquidator gets the audited accounts printed and then sends the printed copy of the accounts to all creditors and contributories. That means after completing all the winding up procedure, that means all the assets are realized, payments made to liabilities and also settlement of contributories. After performing these functions, the accounts of liquidator should be audited by an auditor. So after auditing of all the accounts which he has maintained, the audited report should be sent to every creditor and every contributor. Last one, the company liquidator takes all the actions required for proper exercise of powers granted to him and shall also carry out other duties specified by the tribunal. So whatever orders have been given, what are the instructions have been given by the tribunal, all those instructions, orders should be followed by the liquidator in order to perform the functions of winding up. So in examination, very frequently they may ask you a question regarding what are the duties? What are the duties and powers of liquidator? So in this video, I have explained you the meaning of the term liquidator. and the appointment of liquidator and the reports prepared by the liquidator. And after that, I have explained you about the powers and duties of liquidator. So watch the video till the end to get a complete command on this topic of liquidator. And if you are satisfied with my lecture, give a like to the video. Share my channel in your group, in your friend circle, so that more students can watch the video and enhance the knowledge. Give your comments, and lastly, don't forget to subscribe my channel. Inshallah, we'll continue the next topic in the next video.